Good morning, everybody, and welcome to Family Law Assistance. Today, how are we doing? Like, seriously, how are we doing? Today, I'm that bit too high. It's the only thing we're doing. Right, there we go. Good morning, everyone. There we go. You can only see from my nose upwards. Morning, everyone. Welcome back to Family Law Assistance. Today, I'm going to be talking to you about getting your language right. So, why is this important? Well, it's important because it's about getting the result that you want. Part of the time people don't know what they want, so knowing what you want first of all is really key. And then in court, getting your language right. Now I remember, years ago, going into court, and it was one of those courtrooms that was full of mahogany, had the judge kind of sat up high. Not all court buildings are the same, by the way, but this particular court was like that. And on the one hand, you had one parent with a bundle of documents, and the other side was me and my guy. And on the other side, what you had was a whole ream of expletives. They were talking about my child, my this, my that. And then the issue actually that was being discussed was about a passport. And as the case went on, my guy just kind of kept stum. We had a plan and we knew what we were going to say. But the other side, not so prepared. And because it was a passport, stood up and went, if you beep want the passport, then you'll have to beep. The judge sort of just looked seriously over his glasses. So today I'm going to talk to you about the top 5 tips on how to get your language right. Words really do matter. If you know what you want, then actually it's not just a question of rocking up to court with your proverbial Tesco carrier bag of life and go, right, there you are, mate, sort that out. It's about being really, really focused. So my first top tip number 1, is beware of time. Now, one thing I'll always say to people is that if words were like currency, you're not going to want to waste those words talking about everything else except what you're after. Anybody who's been through court, anyone that's watching this will know that the time you spend actually in court is minimal compared to A, what's happened in your life, and B, the preparation time that you've had prior to this. Often, court hearings are scheduled for half an hour, and I know what you're thinking. You're thinking, oh my God, how am I going to get the judge or the magistrates or the legal advisor to understand all of my issues, all of the things that I want? How am I going to get them to understand? Now, if you watch yesterday's video, I talked all about being organised. It's not quite so sexy, but being organised really, really does help you. Because most of what you're saying, most of your evidence, most of the reports, most of this actually has already been done for you before you virtually walk into a courtroom. My top tip number 2, if you're in a child case, be child focused. Very often, it's amazing how many court cases that I certainly go into, and you've got one parent going, my child, me, and then the other parent talking about the child. So one of my top tips that I get people to do is to practice saying every sentence with your child's name. Just by doing that, it stops you from going off in all sorts of directions. It means that you stop talking about yourself, and more importantly, especially if you're in a child conflict and you're talking about your children, it makes you child focused. If you are in child proceedings, listen, the court is governed by the Children Act 1989. There is no such thing as the Mothers Act 19 whatever. There's no such thing as the Fathers Act 19 whatever. However, what you do have is the Children Act 1989. So anything that you have to say, I would always get people to practice starting their sentences with their children's name. My top tip number 3 is keep it relevant. You would be amazed at the different directions that people go in. Understand what's important about the case, which is, by the way, very different to what you potentially think is important to you. If you're in child proceedings, for God's sake, learn, know and recite the welfare checklist. If you're in financial proceedings following a divorce, get to know Section 25 of the Matrimonial Causes Act. Why am I telling you this? Because it makes everything that you say in your paperwork and the words that you say in court, it makes it relevant. Nobody actually cares if your ex's cat bit the neighbour's mouse and you've got an opinion on that. Keep it relevant. Now, sometimes people need help in what's relevant and what's not. Get a third party to look at, somebody preferably with a bit of clout and knows what lane you're in. So if you're in a child proceeding lane, what is relevant in a Child Proceedings Act? What does need to be considered? Or if you are in a financial case, what's relevant in a finance case? Understanding what relevant is a shortcut to getting what you want. You'll be amazed at how many people don't keep it relevant. You'll be amazed at how many people wander off topic. And listen, it's a human thing to do. It's a human instinct to kind of, in your head, this was important. But from the court case and what the judge has to consider, that may not be important as well. Bearing in mind, you are always going to be selling the solution to the court. You want to make the judge's life easier. So if you're making the judge's life easier, then they're probably more likely than not to agree with you. Top tip number 4, keep it short. It's kind of links with my number 1 tip actually. You have to keep it short. The time that court allocate, especially now, is short. Like I said, a lot of court hearings are scheduled for half an hour, an hour. So you really want to be focused on what you're saying. Less is definitely more. If you've got an issue to raise, then raise it. But let's be real, there's a fine line, and I get it because I help those people go, no, keep on the line. There's a line between, say, raising child-focused concerns and, let's be real here, slagging off the ex. By keeping it short, you're more likely to stay focused. Like I said in my video yesterday, being organised, putting a bundle together, getting your paperwork in order, that's where the real action happens. In court, you're keeping it short. You're keeping it to the point. And then finally, top tip number 5, be consistent. Be consistent in your position. Be consistent in what you're saying. One thing that people who are consistent, especially in family law, get used to doing a lot of repetition. So you'll be saying the same thing in your application. You're going to be saying the same thing to CAFCAS or any other professional that's been drafted in. You're going to be saying the same thing on your statements and in your paperwork. And guess what? You're going to be saying it again to a court. By keeping things consistent, it keeps you focused. By keeping you consistent, you make the court's life way easier. There's nothing more confusing than somebody who keeps chip-chopping and changing their position. And usually it's a sign that people don't know what they want. Morning, Victoria. Okay, you say keep it short, but do the courts ever read the bundles? In my experiences, they don't. Brilliant question, Victoria. Yesterday, I talked all about this because the organisation bit, it's in the bundle. So one thing, especially now that I'm doing, so let's just talk a little bit about Practice Direction 27A. So Practice Direction 27A is the bit of legislation, the regulations, if you will, about preparing bundles. Learn, know and recite it, because doing it in a court format is a surefire winner. Secondly, and I'm going to talk specifically about COVID, because the way that courts were operating pre-COVID, it's a little different now. And so now is probably more relevant to you guys. So what courts, because most of the time, even they're all virtual hearings. There's not many real in-life hearings that are taking place at the moment. So before, you'd have to make sure that you have the Lever Archer files and you send that in. And hey, some courts are still insisting you do that, but they're also accepting electronic bundles. Now, there's a difference between Department A and Department B getting it. So one of the things that I always make sure is, first of all, make sure you send that bundle way ahead of the hearing. And secondly, honestly, the minute you've sent it off, I tend to get people to launch a campaign to contact the court. Depending on where you are in the country, yes, you're going to be on hold. Yes, take half a day's holiday just to get through to them. But constantly making sure that they've got the bundle, and take note of who you spoke to, take note of the times that you've spoken to them, is a surefire way to make sure that the bundle that has been sent actually gets sent over to the judge. The other thing I would say, Victoria, is first up, they do read the bundles, but the way they read the bundles usually is in a very certain way. So I'm assuming, Victoria, that you have got a Practice Direction 27A compliant bundle. What they tend to do is they will always read the Section 8 documents, the bit at the beginning. Arguably, it's your argument. So first thing they'll always do is they'll always look through the index. What's in this bundle? They'll scan their eye down through the index. Then they're going to look at the chronology, because it paints a picture. Your index paints a picture. The fact that what you put in it in the beginning, even though it is Practice Direction 27A compliant, they're going to ask what's in the bundle. Then they're going to look at the chronology. That paints a picture in itself. Then they're going to look at your statement of issues, and then they're going to look at your position statement. The rest they tend to flick through. Now, depending on what kind of hearing it is, I've often seen judges kind of, certainly pre-COVID days, mark out, put tabs, highlight bits and pieces that they want to refer to. So do they read every word? No. But here's where the real thing comes in. I don't know, Victoria, if you're represented or not. Either way, know your bundle, because you become the conductor of your bundle, so that you direct the court to whatever bits of that bundle to highlight your case. Victoria, it's probably the long-winded version, the long-winded version of what you wanted to hear. But check out my video from yesterday, because I kind of go into this, but a great question all the same. So, the judge peered over his glasses. And straight away, looking at the other side, granted my guy exactly what they wanted. You see, courts take a lot on demeanour. It's something that at the moment I feel is being lost. In a virtual world, it's not even virtual, it's a teleconference, let's be real. Most of the court hearings are teleconferences. When we think about the fact that most of our communication is non-verbal, the court misses out on the other side rolling their eyes, the huffing and puffing, which you might hear, but you certainly won't see at a virtual hearing. And in fact, the only thing that we've now got left right now in a virtual court hearing are the words. So let's really make those words count. Guys, I hope you found that interesting. Any questions, as usual, drop them down in the deets, in the comments down below. If you need any help, simply holler. Guys, take care. Over and out.